Madam, all three questions concern the unfortunate death of a prison inmate, Dinesh Raman, son of Chinnaiah, who passed away on 27 September 2010 after he was restrained and relocated to a cell following his unprovoked attack on a prison officer. Madam, every case of death in prisons is taken seriously. Apart from the Singapore Prison Service's own investigations, the police conducts independent criminal investigations to establish the circumstances and cause of death, determine whether any criminal offences have been committed, and identify the persons responsible for the incident. The police's investigation findings and recommendations are then submitted to the Attorney General's chambers to consider whether prosecutorial action is to be taken. In addition to the police's criminal investigations, my ministry will thoroughly review the incident, especially the actions of all parties involved, and the appropriateness of protocols and processes adopted by the Singapore Prison Service. Our aim is to ensure the safety and security of inmates and prison officers, and to maintain the integrity of our prison system of strict discipline and order. Madam, let me first set out the timeline of events to put the incident and the actions that followed in perspective. Prison Service reported Dinesh Raman's death to my ministry on 27 September 2010, the same day of the incident. Police commenced criminal investigations immediately. Separately, the Prison Service reviewed their processes and procedures for the use of Control and Restraint techniques, CNR techniques. The prison officers directly involved in the incident were redeployed from operational to staff duties, pending the outcome of investigations. The police completed its preliminary investigations and referred its findings to the coroner, who convened a mention session on 4th November 2010. The coroner's mention formally commences a public inquiry into the circumstances of the death. On 17 August 2012, the police submitted its consolidated findings to AGC. On 4th February 2013, after reviewing the findings and further clarification with the police, AGC decided to take prosecutorial action. On 1st March 2013, the police informed Minister for Home Affairs that the investigations had been completed. After being briefed by the police on its findings, the Minister decided to appoint a committee of inquiry to conduct an independent audit of prisons' broader systems, processes and protocols for bringing violent inmates under control. On 4th June 2013, Ministry of Home Affairs accepted the findings and recommendations of the Committee of Inquiry and directed Prison Service to implement them immediately. All the recommendations have since been implemented or are in the process of being completed. The charge against a senior prisons officer who was the direct supervising officer of the incident was heard in court on 19 July 2013. DSP Lim Kuo Yin pleaded guilty to the charge of causing death by a negligent act and was fined $10,000. Madam, it took 28 months from the commencement of police investigations to the Attorney General's decision to prosecute. This was due to the complexity of the case. Let me elaborate. The police investigations included a thorough study of the control and restraint doctrine, training, protocols and techniques used in prison. It entailed meeting external experts, both domestic and international, to seek professional views and an assessment on the CNR techniques deployed. And it involved interviews with 130 witnesses, comprising 72 prison inmates, 23 prison officers, 8 prison medical staff, 7 police officers, 2 Cisco officers, and Dinesh Raman's next of kin. In total, the police conducted 144 interviews. Police investigators also went to the United Kingdom to consult a CNR expert from the National Tactical Response Group under the UK Ministry of Justice. In comparison, the recent Shane Todd case, which took 13 months for the state coroner to reach a verdict, involved 60 witnesses. That case did not involve criminal charges. Another example is the Yishun triple murder case of 19 September 2008, which concluded with a conviction 4 years later on 20th November 2012, and that involved 68 witnesses. Madam, the prison environment is complex, and the risk of security incidents is real and present. Strict discipline and control is essential to maintain a safe and secure environment for both inmates and prison officers. While the number of violent incidents in our prisons is low when compared with other jurisdictions, they do happen. Last year, there were 61 assaults by inmates, 40 of which were against other inmates and 21 against prison officers. We have zero tolerance for any violence or abuse that could adversely affect order and discipline in our prisons, because it is the foundation for the effective rehabilitation of inmates. To achieve this, our prison officers are trained in control and restraint techniques, which involve using both defensive and control methods to subdue a violent inmate swiftly, safely, and decisively. Our prison service adopted these team-based CNR techniques from the UK CNR Training Centre in June 1990. They have been adapted to our local prison environment and are in line with international best practices in the UK, US, and Hong Kong. CNR techniques follow a fixed procedure that involves teams of prison officers, each with a specific role or task. The procedure enables prison officers to use reasonable force in a controlled manner to restrain and manage violent inmates and to gain quick control over the incident with minimal injuries to all. Over the last 4 years, our prison officers have had to use CNR techniques 331 times to deal with a range of violent incidents. Prior to the case of Dinesh Raman, no prison inmate has ever died or suffered serious injuries as a result of CNR techniques. The Committee of Inquiry assessed that the CNR techniques are safe, useful, and appropriate for managing violent inmates, as long as safety precautions are observed. The COI did not find any malice in the actions of prison officers involved in restraining Dinesh Raman. However, the Committee of Inquiry identified specific areas for improvement given the way the CNR techniques had been used in this incident. For example, the officers involved did not maintain constant communication with Dinesh Raman, as required by the Standard Operating Procedure, in order to monitor his overall condition. The COI also found that officers should have been more conscious of the risk that the CNR techniques might cause positional asphyxia and of how to prevent this from happening. All our prison officers are trained in CNR techniques. In addition, officers directly managing inmates are required to undergo CNR recertification biennially. In response to the Committee of Inquiry's recommendations, The Prison Service has reviewed its CNR doctrines, instruction manuals and training materials to place greater emphasis on the risk of positional asphyxiation and preventive measures. The Prison Service has also reviewed its recertification requirement to ensure that all supervising officers are covered, including the superintendents of prisons, even though they may not need to directly apply CNR techniques themselves. In addition, the Prison Service has introduced new protocols, such as applying CNR techniques on violent inmates in a standing position where possible, to reduce the risk of positional asphyxia. These new protocols have been adopted and adapted from the other jurisdictions, such as the UK prison system and the Hong Kong Correctional Services. Following the conviction of the senior prison officer on 19 July 2013, Ministry of Home Affairs has been in touch with the family of Dinesh Raman and their lawyer to discuss the family's concerns as well as the matter of compensation. AGC has informed the family and its lawyer in writing that the government accepts liability and will compensate the family. As discussions are ongoing, I am not able to provide details. In closing, the Committee of Inquiry has found that the Prison Service's overall system and processes for managing violent inmates are appropriate, safe, and effective. The COI made recommendations to improve specific aspects of the CNR techniques, which have since been acted upon. Ministry of Home Affairs recognizes that maintaining order and discipline for the safety and security of inmates and prison officers is a difficult and challenging task. Nevertheless, we expect prison officers to perform their duties with integrity and professionalism. It is important that the Prison Service has a team of disciplined and well-trained officers who obey the law and manage inmates conscientiously according to rules and procedures. We take a serious view of any professional misconduct, procedural lapses, neglect, or excess of duty by prison commanders and officers, and will take firm action against them according to the law and civil service disciplinary processes. This is important in order to maintain public confidence in our institutions and indeed in the people who continue to serve in them. With the conclusion of the court case, the Ministry of Home Affairs has initiated disciplinary action against the superintendent, supervisors, and other officers involved in the incident.